forfeiture as a fine imposed on the second respondent for the proceeds of narcotics and money laundering by the District Court of Illinois. I sat down through, I did not hear it, and I wonder whether that was swept under the carpet or was an oversight, because the lead judgment was detailed on all other issues, and they said all the issues there have been overtaken by event in all our own issues, and I did not hear the issue of the forfeiture. And so that's why I said I disagree respectfully, even though the decision is binding.
The 4% issue has also been laid to rest.
Yes, it has been laid to rest. The Supreme Court has the authority to interpret the Constitution. It is their prerogative as the arm of government imbued with the power to interpret. That is the interpretation they have given to it, and it is binding on us all. That's what I'm going to say on it.
What's your take on the reasoning on IREF? How does it going to affect our future elections?
That is very interesting, because the only paragraph the Supreme Court brought to the notice of the world, which was quite interesting, is that even the Supreme Court agreed that non-uploading of the result on IREF reduced the confidence of the people in the election. I heard it clearly. Meaning that even the Supreme Court agrees that the election was not credible, or as credible as it ought to have been if the result was uploaded. So credibility is one of the three arms of an election for the people. Free, fair, and credible. Credible means believable. Why shut out the people for the rights the law has given unto them? So I was very glad that the Supreme Court pointed it out, that non-uploading of the result reduced the confidence of Nigerians in it, meaning that it cannot be presumed to be credible because Nigerians were shut out in it. So I loved that particular part. Thank you. Thank you. Thank you.
Shame, 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 shame on Tinubu. Shame, 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 shame on the Supreme Court judges that are going to be sitting on this appeal case of Atiku and Obi. Shame, 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 shame on you. Shame on you, wicked, greedy people. Tinubu, you think money is everything. You think you will use money to bewitch Nigeria. Your witchcraft is coming to an end. Wherever you went and got all the concoctions that you think you can, come and use that all over Nigerians and silence them that they can do nothing. But I'm telling you, witchcraft has an expiry date. Your witchcraft, Tinubu, the witchcraft of all the people you have surrounded yourself with, all the babalaos and whosoever the people that you have bought using money, your money perish with you. I say all the people that are around Tinubu to enable him, people like Wicked and Gwajamila and all the others, God will punish you. You have no hiding place, including the so-called APC rogue chairman, the one that is the dollar thief. And now it's a combination of thieves. People that should have been arrested and been behind bars. They're the ones that are trying to govern this nation. Greedy, wicked cowards. And suddenly, the judgment that they had planned to be for the 2nd of November, they quickly rushed. And you, wicked Iyan Okoro, that you come from the south, close to the southeast, and your name is Okoro. Instead of standing in defense, when have you seen somebody, an Igbo man, become president in Nigeria? Everything must be from the north. I'm from the north. But I'm telling you, greed and selfishness is the reason why the people are being oppressed in the south. You hardly see that among northerners. Northerners, no matter what issue they are having, they will still stand together and defend themselves. I'm telling you, That's why you can see already, so most of the people from the far north are already standing against Tinubu because they had an agenda for the Muslim ticket, and they say it's not dancing according to their tune. That's why they're not in support of Wike being the minister of FCT. They said he should have been a Muslim because historically it's always been Muslim. I say again, shame on Tinubu, shame on the tribunal. They want to rush because they want to use technicalities. Wicked people that have no heart, and they are going tomorrow to go and pervert justice. Now, if you are bold enough, why don't you wait for the 2nd of November and do the judgment quickly? Now they rush to go and do their kangaroo court. Evil people. When the people have been saying that the justice, the judiciary is the last hope of the common man. But let me say this, the judiciary are the last ones that have come to squeeze the remaining life that the common man has. Everything is about money, 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 money. Your money perish with you, Tinubu. Your money perish with you. All of you judges that receive money to pervert justice, and they want to go and use technicalities. Weak people. You can't stand Nigerians. And small time, they will say want to use the army and the police. Any right-thinking police, any right-thinking army should not side with these people and work against 200 and something million people. How many are they? Why should you people allow money to sell your conscience? And then Nigerians are stuck, and everybody will just go into his house and say, well, this is Nigeria, this is Nigeria. You know, Nigerians, we are the ones enabling these people. By now, there should have been uproar everywhere. By now, there should have been protests everywhere. And then some people are still saying, let's remain hopeful. You hoped during the election, you hope that 25th of February will deliver the right candidate. Did it happen? Mahmoud Yakubu went and announced the election, the stolen election, stolen mandate. Then we spoke to you and we said, stand up and reclaim this mandate. Don't let them swear Tinubu. If you let Tinubu go in, he's a rogue, he's a crook. He will go in there, use money, bribe everybody, and silence everybody. Now that he is so-called commander-in-chief, just wait and see. You haven't seen suffering. Buhari is child's play, is kindergarten. It's a nursery school torment. You haven't seen anything. The suffering that people have suffered in Lagos, where Tinubu made Lagos his private business. He's about to do that in Nigeria. Can't you see his appointment? Appointing people, just dashing people. He has more media advisors than he has security, than he has people that will bring change in Nigeria. And he hasn't done anything about the economy. Everything is gone down. He hasn't done anything about security. Has he done anything about your life? Few wicked people have held us hostage. And some people are just saying, let's wait and see. Wait and see what? Tinubu is wicked. Everyone that is behind Tinubu is evil and wicked. Nigerians, when will you wake up from sleep? Tomorrow is Thursday. They want to come and uphold Tinubu's presidency. Now, judges, prove me wrong. You say I'm threatening you. Did we not speak the same way? But what did Justice Samani did with the tribunal court? We said they have already written the judgment, and they're just coming. That's why they came like to shame and disgrace Nigerians. Listen, let me tell you, this is not about Obi. This is not about Atiku. It's about Nigerians. They have suffered enough in your hands. Nigerians, so what will you do? Tell me, what will you do? Tinubu has paid the judges to uphold his presidency. That's why they're rushing to give this judgment. They can't stand the FBI bringing out all the things about Tinubu. So now, okay, let them go ahead and uphold it. And then, Nigerians, I'll see what you would do after all the files come out. Because Tinubu would have paid them and bribed them in America not to release the files. But America is not crooked like Nigeria. And that's why they're still going to do it. And they may do it only after Tinubu's presidency has been upheld. So what will you do as Nigerians? You're waiting and waiting. Well, I don't need to talk so much again. But I'm just saying, shame on you, Tinubu. Shame on all your supporters. Shame on all your enablers. Especially top shame on the judges. You are supposed to be the last hope of the common man. Money, selfishness, greed. Your families will never know peace. You will not spend that money. You will perish with the money. It will not be well with you. If you pervert justice this Thursday, that you rush to go to declare this. And listen, if you people know that what you're doing is right, don't release the army, don't release the police. Because why should you be afraid? They are afraid to face the cameras because they know their ways are evil. Wicked people. Nigerians, wake up, wake up. They don't care about you. Reclaim your nation. Every Nigerian, north, south, east, west, male, female, Christians, Muslim, everybody is suffering. Enough is enough. This is the time we must say no to every political thuggery, to every tyranny. Listen, it's not only the Asare Dokubo that he has the monopoly of protest. And each time he comes, do you hear them arrest him? But then the rest of you are all scared. The rest of us were all scared and say, I don't want to die. You're already dead. Nigeria is like finished. They've just come for the burial. You allow Tinubu, he's just coming to finally bury Nigeria. So do you want the funeral of Nigeria? You say, but you're not speaking like you have faith. I have faith. I'm speaking out of faith, and I want to wake you up that you must do something, not later, but now. Don't wait for the judgment. Take your own judgment in your own hand. Take your destiny into your own hand. Because they don't care about you. They want you dead. Not tomorrow, but yesterday already. They are not coming in to serve your interest. It's their belly. Judges in Nigeria are evil and wicked. And I don't mean every judge, but any judge that cannot stand for justice is evil and wicked. If a judge recalls, tells himself, I will not stand in the tribunal, or I will not be, please excuse me from being on the ground that I'm being threatened and I want to stand for what is right. No, you should have come forward and taken a stand and stand for justice. Oh God, help us in this nation. Wake Nigerians up. Wake every Nigerian, from the old to the young, from the young to the old. Wake them up to reclaim their nation from these evil politicians. Shame on every politician. Shame, 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 shame. Those of you that are in Aso Rock, that are not standing for the people, shame, shame, shame on you. Those of you that are in the House of Reps, those of you that are in the Senate, that all you're doing is sharing money. Even shame on those that are from Labour Party. Shame on those that are from PDP, that went there and they say, we don't want APC, we want change. And you went there, when you saw money, you seared your conscience, you forgot why you're there. God will punish you. It will not be well with you unless you repent, unless you stand for the people. Nigerians, these people don't care. You have to take a stand. Take a stand now. Let's unite as a nation against these people. Starting from now. Please go ahead and share this broadcast with as many people as you can. Where, it's no longer just a speculation that the judgment is now being fast forwarded a week earlier, and it's going to be this Thursday, 26th. That's how evil Tinubu is. Everything about Tinubu is conniving, lying, cheating, forgery, and everything that is evil. Tinubu's brain is wired to operate like that, and the people that are around him. But their end has come. Your end has come. Your end has come. Divine judgment is coming on all evil workers, all connivers, all cheats, all crooks. Your judgment has come. When people are saying, who is this Dr. Haruna from Kaduna State? He's not a real Northerner. Northerner what? Don't use Northerner on me. The people have been using, where they come from to rob from people. Are you not seeing people from the Southeast that are siding with the same rogues, the same thieves? because of greed and selfishness. But you will not live forever. God will judge you, expose your wickedness. But Nigeria will stand, and God himself will protect Nigerians against you evil connivers. Thank you very much for watching. Go ahead and share this broadcast with as many people as you can. Just keep watching on. We'll be bringing, what's going on. But please do what you can do to ensure that this nation is free. Let's take a stand together and let Nigeria be free.
By the petitioners on the admissibility of several documents sought to be tendered by the appellants. After resolving all the issues in favor of the respondents, the lower court dismissed the petition for lacking merit. Dissatisfied with the dismissal of the petition, the appellants filed a notice of appeal on the 18th of September 2023. A brief facts of the case giving birth to this appeal are that election into the office of President of the Federal Republic of Nigeria was conducted by the Independent National Electoral Commission, INEC, on 25th February 2023, wherein the second and third respondents emerged winners with a total of 8,794,726 votes, while the appellants came second with 6,984,524 votes. 16 others participated in the said election. The first respondent accordingly declared the second and third respondents winners of the election and declared the second respondent as the elected president of the Federal Republic of Nigeria. Aggrieved by the outcome of the election, the petitioners jointly filed a petition at the court below to challenge the outcome of the election under 4 grounds as follows. A, that the election of the second respondent is invalid by reason of non-compliant Electoral Act 2022. B, that the election of the second respondent is invalid by reason of corrupt practices. C, that the second respondent was not duly elected by a majority of lawful votes cast at the election. And 4, the second respondent was at the time of the election not qualified to contest the election. The appellants as petitioners then sought the following reliefs. 1, that it may be determined that the second respondent was not duly elected by a majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent by the first respondent as the winner of the presidential election conducted on the 25th day of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. That it may be determined that the return of the second respondent by the first respondent was wrongful, unlawful, null and void, having not satisfied the requirements of the Electoral Act 2022 and the Constitution of the Federal Republic of Nigeria 1999 as amended, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. That it may be determined that the second respondent was at the time of the election not qualified to conduct the said election, to contest the said election. That it may be determined that the first petitioner, having scored the majority of lawful votes cast at the presidential election on Saturday, 25th February 2023, be returned as the winner of the said election and be sworn in as the duly elected president of the Federal Republic of Nigeria. In the alternative, number 5, an order directing the first respondent to conduct a second election, that is run-off, between the first petitioner and the second respondent. In the further alternative, 6, that the election to the office of the President of Nigeria held on the 25th of February 2023 be nullified and a fresh election rerun ordered, and any further reliefs as the court may deem fit to make in the interest of justice. Upon being served with the petition, all the respondents joined issues with it by filing their respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. On 6 September 2023, judgments in the petition, including rulings in the applications, were rendered by the court below. As I said earlier, the appellant's petition was dismissed. Dissatisfied with the stance of the lower court dismissing their petition, the appellants have appealed to this court. Notice of appeal was filed on the 18th of September 2023, containing 35 grounds of appeal. Appellants filed their brief of arguments on 2nd October 2023, while the first, second, and third respondents filed theirs on the 7th of October, respectively. On 6th October 2023, the appellants filed a motion on notice seeking 2 orders from this court. And at the hearing of the appeal on 23rd October 2023, the said motion was taken first and ruling reserved till today. I shall proceed to determine the said motion before resolving the issues in this appeal. Motion on notice filed on the 6th of October 2023. As I alluded to above, the appellants filed motion on notice on 6 October 2023 seeking 2 orders from this court, to wit, A, an order of this honorable court granting leave to the appellant applicants to produce and the honorable court to receive fresh and or additional evidence by way of deposition on oath from the Chicago State University for use in this appeal, to wit, certified discovery deposition made by Caleb Westberg on behalf of Chicago State University on October 3, 2023, disclaiming the certificate presented by the second respondent, Bola Ahmed Tinubu, to the Independent National Electoral Commission. B, and upon leave being granted, an order of this court receiving the said deposition in evidence as exhibit in the resolution of this appeal. The grounds for the application are well set out in the motion paper, and there are 20 in number as follows. 1. One of the grounds of the applicant's petition before the court below is that the second respondent was not qualified at the time of the election to contest the election, as required by Section 137(1) sub 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. 2. Based on facts available to the applicants at the time of filing their petition, the first appellant applicant, through his United States of America lawyers, Alexander de Gramont and Angela M. Liu of the law firm of Dockett LLP of 1900 K Street, NW, Washington, D.C., 20006 to 1110, unsuccessfully applied to Chicago State University for the release of the copies of the academic records of the second respondent. Given this, number 3, given the strict privacy laws in the jurisdiction of the Chicago State University, the request for the release of the academic records and certificates issued to the second respondent could not be granted without an order of court and for the purpose of use in pending court proceedings. The first applicant, through his said U.S.-based attorneys, thereupon brought an action in the U.S. District Court for the Northern District of Illinois in re application of Atiku Abubakar for an order directing discovery from Chicago State University, case number 23CV05099, for an order for the production of documents and testimony for use in a proceeding in a foreign court, seeking documents and testimony from Chicago State University concerning the authenticity of an origin of documents purporting to be the educational records of the second respondent, Bola Ahmed Tinubu. 5. The second respondent applied and was joined in the matter as an intervenor, vehemently opposing the application. On September 19, 2023, the court issued an order granting the application. 7. Thereafter, the second respondent applied for an emergency stay of the court order, claiming that he would suffer irreparable damage and injury if his educational records were released, which order of stay was granted. 8. On September 30, 2023, the court overruled the second respondent's objections and ordered Chicago State University to produce the documents on October 2nd, 2023, and to produce a witness for deposition on October 2. Then on October 2, 2023, Chicago State University produced the documents pursuant to the court's order. 10. On October 3, 2023, also pursuant to the court's order, Chicago State University provided a witness to give deposition testimony, in which deposition Chicago State University disclaimed ownership and authorship of the document that second respondent presented to INEC, purporting to be Chicago State University certificate, and also disclaimed issuing any replacement certificate to him. The deposition was not in existence, or that's number 11. The deposition was not in existence or available at the time of filing the petition or at the hearing of the petition. The deposition number 12 sought to be adduced is, along with its accompanying documents, such as would have important effect in the resolution of this appeal. 13. The deposition is relevant to this matter, having confirmed that the certificate presented by the second respondent to the Independent National Electoral Commission did not emanate from Chicago State University, and that whoever issued the certificate presented by the second respondent did not have the authority of the Chicago State University, and that second respondent never applied for any replacement certificate, nor was he issued any replacement certificate by Chicago State University. The deposition which is on oath, that is number 14's ground. The deposition which is on oath deposed to in the presence of the second respondent's attorney is credible and believable and ought to be believed. 15. The deposition is clear and unambiguous, and no further evidence is needed to be adduced on it. 16. The evidence is such that could not have been obtained with reasonable diligence for use at the trial, as the deposition required the commencement of the suit in the United States of America before receiving same. It was not possible to obtain the said evidence before the trial at the court below. 17. The deposition was made on October 3, after the conclusion of trial at the court below, and was not available to be tendered at the trial court. 18. Presentation of a forged certificate to the INEC by a candidate for election to the office of President of the Federal Republic of Nigeria is a weighty constitutional matter requiring consideration by the court as custodians of the Constitution. 19. The original certified deposition has been forwarded to the Honorable Court by a letter addressed to the Chief Registrar of the Supreme Court. And 20, the last, it is in the interest of justice for this Honorable Court to exercise its discretion in favor of the appellant's applicants. In support of the said application is a 20-paragraph affidavit deposed by Uyigiwa Osage, Nigerian citizen, a legal practitioner, and legal advisor to the first appellant, with exhibits A to H annexed. Learned Senior Counsel for the appellant applicants, Chief Csu Cert, SAN, leading other senior and other counsel, filed a written address in support of the motion. Upon receipt of the said motion on notice, the first respondent filed an 11-paragraph counter affidavit deposed by one Gift Nwadike, a legal secretary in the law firm of Diko and Mahmood, lead counsel to the first respondent. A written address in opposition to the said motion was also filed and signed by A.B. Mahmood SAN, lead counsel for the first respondent. For the second respondent, Senator Michael Okpeyemi Bamidele, a legal practitioner and long-standing associate of the second respondent, deposed to a counter affidavit of yet again 20 paragraphs on 12 October 2023. Annexed to the counter affidavit are exhibits 1 to 9. And in support of the counter affidavit and in opposition to the motion, Learned Senior Counsel for the second respondent, Chief Wole Olanipekun SAN, leading senior counsel and leading other counsel, filed a written address on the same date the counter affidavit was filed. The third respondent's counter affidavit was deposed to by one Peter Emma Iko, a legal executive in the law firm of Olujinmi and Akeredolu, lead counsel for the third respondent. The 9-paragraph counter affidavit is supported by a written address filed and signed by Chief Akin Olujinmi SAN. Upon receipt of the various counter affidavits, the appellants filed a further affidavit of 20 paragraphs deposed to by the same Uyigiwa Osage, with 12 exhibits further annexed. Learned Senior Counsel also filed reply on points of law to the written addresses filed by the first, second, and third respondents in their opposition to the appellant's motion on notice for fresh evidence and or additional evidence. At the hearing of this motion, both the applicants and the respondents adopted their supporting and counter affidavits respectively. They also adopted and relied on their various written addresses. In the applicant's written address, the Learned Senior Counsel submitted one issue for determination, to wit, whether this Honorable Court ought to exercise its discretion in favor of the appellant applicants by granting the prayers sought. The first respondent's Senior Counsel also donated a sole issue for determination as follows: whether in view of the peculiar facts of this case, this Honorable Court can proceed to grant the instant application. For the second respondent, Chief Olanipekun SAN submitted one issue, which states, considering the background of this case, as well as the applicable constitutional and statutory provisions relevant to election appeals and proceedings, whether this Honorable Court will grant this application. Finally, Chief Akin Olujinmi SAN, leading other counsel for the third respondent, opined that the crucial question to be addressed in this motion is whether this court has jurisdiction to entertain this application. Now, taking a clinical look at the four issues, it is crystal clear that they all say the same thing. And put in simple terms, it is whether the law of Nigeria, as presently constituted, allows this court to receive the evidence in question and act on it at this stage. In his argument, the learned senior counsel for the appellants submitted that this court has the power, the jurisdiction, and the discretion to grant an application to adduce fresh and or additional evidence on appeal, referring to Order 2, Rule 12.1 and 2, and Rules 12.1, 2, and 3 of the Supreme Court rules, and the case of Uzodinma and Izunaso, citation supplied. Learned senior counsel submitted that the grant of this application will be in furtherance of the cause of justice. That this is a case in which the second respondent was purportedly declared as the winner of the election to the office of President of the Federal Republic of Nigeria, and the appellant applicants have, amongst other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission. That the appellants have also a challenge in their appeal, the striking out of their pleadings, raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Saleh and Abba citations supplied, the learned senior counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the learned senior counsel for the first respondent, A.B. Mahmoud Essay, submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis, and as such, this court, in determining this application, must take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant's applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago, UBA PLC and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obo and Enable is limited. Learned senior counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Caleb Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okonkwo and registered trustees of Jude Anglican Church, citation supplied is submitted that evidence not supported by pleadings goes to no issue. Leonard Silk further submitted that insofar as the deposition of Caleb Westberg is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 24th day of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days of the second respondent's submission of his form EC9 or the publication by the first respondent. He urged the court to so hold. According to Leonard Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westberg, which seeks to establish a case of forgery against the second respondent without more, cannot ground a conviction for forgery of as proof beyond reasonable doubt cannot be solely based on an affidavit evidence, relying on Abubakar and INEC, Agi and PDP, Mohammed and Wamako, all citations supplied. Leonard Silk argued further that the deposition of Caleb Westberg alone does not, under our law, constitute credible evidence to establish a case of forgery. Finally, the Leonard Silk submitted that this appeal, being based on an election matter where a trial court is to hear matters and deliver judgment not later than 180 days after the filing of the petition, the implication is that all evidence ought to be adduced at the trial court and judgment delivered within 180 days. That it was not the intention of the draftsman of the Constitution to allow and permit the receipt of evidence in an election matter when the court vested with the powers to receive evidence, has lost jurisdiction over the matter. He wondered what would happen now that all parties have filed and exchanged briefs with no arguments canvassed in respect of the additional evidence sought to be adduced in the instant appeal. There being no room to extend time under the pre-election and election appeals practice directions 2023 of the Supreme Court, he urged the court to dismiss the application. In his contribution in opposition to the grant of this application, Leonard Senior Counsel for the second respondent, Chief Olanipekun S.A., submitted that this court is without the virus to consider the said deposition either as oral or documentary evidence, more so when the evidence was not considered by the court of first instance within the 180 days time frame provided by the Constitution of the Federal Republic of Nigeria, relying on the recent case of Towo, Womo, and Ajayi, unreported, delivered on the 27th of January 2023 in this court hall. That the lower court, having lost its jurisdiction since 17 September 2023, upon expiration of the 180 days from the date of filing the petition by the appellant, this court cannot grant this application. That section 22 and 23 of the Supreme Court Act give power to order 2 Rule 12(1) of the rules of this court, and that can only happen if the lower court still has jurisdiction. Referring to Omubilari and Igbo Asoi and others, and Adegbite and Omosun, all citations supplied, the Leonard Silk contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the Leonard SAN, the failure of the appellant applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application. Relying also in Obasi and Onwuka, Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure 32A1A, the learned Silk opined that the failure to invite the All Progressives Congress and the Independent National Electoral Commission to participate in the deposition made in the United States renders Exhibit C and D inadmissible. More so, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D have no utility or affinity with this appeal, for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, learned senior counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction to try the case of forgery. He urged this court to refuse this application and hold that it is an abuse of court process. For the third respondent, Chief Akin Olujimi SN made submissions which are similar to those by the learned counsel for the first and second respondents. With due respect to the learned Chief Silk, I shall refer to them in the process of resolving the sole issue in this application.